there's been a corruption of the currency, and so all kinds of, so you'll hear a journalist speaking to an ex-senator refer to him as senator.
I still call my old boss senator,
Yeah.
even though he's
Who, which one?
Carl Levin.
Oh, yes, that's right.
Well, actually,
He
I only
could
do it in
have,
public.
did he
He's
have a,
mostly
ti-
Carl in front of everyone.
did he have a, was he ever governor? No, he wasn't.
was not.
No. But part of the corruption of Washington is to spend.
Inflate or-
Inflate titles.
What about the
Well, not on
military?
this-
Is
Not on
general,
this panel.
but it's retired general, so you never,
Yes.
you're still general.
My wife was at a cocktail party at George Will's. He has one every year for the baseball team. And she met an officer and asked whether he had ever served in Afghanistan because she is involved in charity. And he said, yes, actually I served in Afghanistan and I was chief of staff in the Army, General Casey. My wife tries to recover and says, oh, you're that General Casey.
It's good recovery.
That is a good recovery.
You don't have to get up. Jeff
Good to
Rosen.
see you.
Good to see
Good to
you.
see you, Jeff.
Hey, Jeff, Steve Croley, how are you?
Nice to see you.
Nice to see you.
Hi, Ilona Cohen,
Well,
pleasure.
nice to see you. I'm Jeff Rosen.
My pleasure.
This is really an enormous distinguished group that I have to introduce. I'm going to be very brief. Now, incidentally, each one of you gets 5 minutes.
Great,
You really get 5 minutes.
You cut us down from 6. Okay.
yeah.
Well, can you do 6? Are you ready for 6? I'll
5 is
do
fine.
6.
I can do
5
it
is
4.
more than-
I can talk fast.
I can
5 is
also
great.
speak very
Let's
fast.
do 5 minutes.
5
then.
is great.
Can you do 5 minutes?
I think so.
I will cut you
I
off.
haven't timed it, but I think so.
Good.
You can cut me off.
Because of the conversation.
I'll do even
will
less.
be-
You're right,
We
you're
start
right, you're
here
right.
and go down so that I can piggyback
I
on.
mean,
We're going to speak from the table as opposed to the podium, or
which would you prefer?
I prefer the table.
Let's do the table.
I'm good either way.
Let's do the table.
Then we save more time for all the tough questions you're going to ask us.
Me? Why would I do that? I'm hoping the audience will ask tough questions.
I'm sure they will.
Hey, Steve, testing.
I mean, this is not, of course, a burning topic at all. Or would I say, probably the most burning. Other than any prosecution coming out of the Justice Department.
That's right.
I told Rod Rosenstein the other day at a cocktail party I saw him, and I said, I thought I had the most difficult job as Deputy Attorney General that anybody ever had in American history. I take that back.
To be sure.
I'm assuming there's another meeting that's about to break up.
Yes.
Otherwise, we're going to have a lot of fun just talking amongst ourselves.
Well, as you mentioned, this is a distinguished panel, so I'm looking forward to chatting.
The only one we're missing is my ex-law clerk.
Was he late when he clerked for you?
Never.
I think people are wandering down because we're downstairs.
Lost.
And
As a matter of fact, Jeff, not only was my law clerk, he married another of my
Oh, really?
law clerks.
Oh, is that right? Did you marry them?
Yes, well, you have to be very careful with saying, years ago, I was involved in a case and then I recused, and one of the lawyers asked me afterwards why, and I said, well, because I married the other lawyer's daughter. He said, my God, I didn't even know he was divorced. I said, no, that's not what I meant. How are you,
Your Honor.
Al?
Good to see you.
Good to see you.
Hey, Jeff, Steve Croley, how are
Hi,
you?
Jeff Harris, how are you?
Hi, Ilona Cohen, pleasure.
Pleasure, nice to meet you.
I understand you're taking Jen Mascot's job?
The same firm, yeah. We'll be,
Oh, okay. Oh, I thought you were doing the clinic.
so that'll be part of it, but,
Okay. Sorry if I didn't know.
oh, no.
I wasn't supposed to announce. Anyway, she's a friend. and-
Oh, terrific,
Yeah.
oh, wonderful.
Well, are we making any announcements?
Monday, but
Sorry.
afraid of
that
maybe-
soon, huh?
Yeah, so,
Wow.
a little bit of a whirlwind, but,
Well, congratulations.
thank you.
Well,
No,
let's all sit down, don't we?
Please.
Is everything good?
Jeff, you're next. Where are
First,
you, Jeff? Yeah, you're in the middle, Jeff. Two Jeffs.
we alternate every other speaker's a Jeff. We're going to do that with the questioners as well?
Mike.
Steve, when were you clerking for Steve Williams?
In, let me think, in 1991, 92.
When
Oh,
were you
wow.
It's been a while.
What?
The last 2 years.
Yeah.
Yeah.
Out of where?
Did you,
Out of which law?
were you in 244?
Out of Yale Law School.
In the EOB?
Yeah, he was
I
more
was
inclined.
that big office
get
in
Yale's
the
and
corner
ours.
across
Yeah.
from the OIRA
He,
administration.
Oh, okay,
he was
yeah,
more
yeah, so that's state.
Catholic.
I was
In his, yeah.
on the other side of that, which I think
Yeah.
has historically been the
Back
case.
in those
Kind of
days, we
Lyra's
all
pulled it in
thought
as
he
the
would take
associate
Yeah,
administrator office.
one
Yeah, I
pretty
heard
far
But now
that-
yours, your
one
that
pretty
was
far
state
to
was
the
the
right,
GC.
and one in the
Oh, did it? 'Cause
center,
somebody
and
told
we
me
all
that the GC
hypothesized who was
lost
who.
Briefly, because they had all of this like shuffling.
That's not
because
necessarily
of the
true.
wild
It was
west,
more-
all of
it
these
just
senior
turned out
advisors
that
who weren't
It turned out that
confirmed,
way,
and so
Right.
they couldn't have the office.
It
They
was
were supposed to
they
have
go
something
to
from
his
other office, which was
soiree
appropriate for
last
them.
year.
Sorry?
There was a ceremony
amazing
for
how
him
much
in the
people
courtroom last year.
Yes.
Kind of about
Yes.
these little
Well,
status
it's funny
things.
because that
That's how
office
it's-
was huge. I never had enough space.
Gigantic.
I
You know,
never
we
had
were
enough stuff to put on it. So
classmates.
like the walls remained
Lovely.
mostly blank
think I knew
the
that.
entire time that I was
Your
there.
classmates, law school classmates.
Yes. You're kidding. We don't have anybody here.
They'll be filling it. They'll be filling it, but we gotta keep the, we take a minute or two. but-
It's not quite 10:45.
I'm at a health technology company. I'm the GC of a health technology company called Aledade. So I've gone to
Yeah, you
heavily
don't have
regulated
anybody
to
here.
being heavily regulated.
I know, we're gonna keep it tight, but there's no point in starting with nobody here.
Whenever you'd like to start, it's fine.
Yeah. But is there another session breaking up? Is that the problem?
The problem is,
I was in the White House counsel's office before that. I started at, well, I'll give you the whole bio.
you're starting at 12:30.
You really jammed it up. It's a shame to have such a distinguished group here and not have anybody there to listen.
Well, we have the video and the live cast, so.
All right, well, I'm told we should start, even though it sounds, given this paucity of attendance, we may be just talking amongst ourselves. I'm Judge Silberman, I'm the moderator, and I'm to quickly introduce the panelists. And I say quickly because they all have such a distinguished record that I'd use the whole time if I described the whole record. Ilona Cohen is the Chief Legal Officer of Aledade, a health care technology company. She has had various jobs on the Hill and in the White House, including General Counsel of OMB. Steve Croley is a partner at Latham and Watkins, has served in the White House as Deputy Counsel for President Obama, as well as General Counsel for the Department of Energy. I should mention he actually served as law clerk to my classmate and dear friend Steve Williams. Jeff Harris has a disreputable background. He recently served as Associate Administrator for OIRA at OMB, was previously a partner at Kirkland & Ellis. He's left government, and nobody knows where he's going. Unfortunately, he also clerked for me. Jeffrey Rosen is presently Deputy Secretary of the Department of Transportation. He previously served as the department's general counsel and was a senior partner at Kirkland & Ellis. He, like others, has also served as general counsel of OMB. So we have an enormously distinguished panel to talk about regulation. And I will turn it over first to Ilona. Ilona, do I pronounce that correctly?
It's Ilona.
Why
I'll take
is it-
anything close.
There's an O, not an A.
You'll have to bring that up with my parents.
Where are they?
They are in Michigan.
Okay, I will do it. Ilona Cohen is the first speaker.
Thank you so much, Judge, and thank you to the Federalist Society for inviting me here. It's great to be here, and unlike most of the sort of initial speakers at the Federalist Society, I was intending to talk about the Obama administration sort of rulemaking process and really to debunk some myths that I was actually hearing this morning about the rulemaking process during our administration. So first was some discussion about the process that we used. And, you know, if you listen this morning and certainly in the media, you might come away with a wrong impression that, you know, the Obama administration was some lawless administrative state. But in fact, there were massive rulemakings to be sure, but the truth is that the administration brought a tremendous amount of experience to bear in the rulemaking process, went through multiple rounds of notice and comment rulemaking, and came up with some very thoughtful and well-reasoned rules. And I think, by contrast, we have yet to see really whether this administration will do the same. Despite the perception that there has been a massive amount of deregulation in the first year of this administration, I think a lot of that deregulation has taken place through, in the form of delay of Obama-era rules, but also through the use of the Congressional Review Act. And so the tough business of notice and comment rulemaking, in my opinion, is not quite upon us yet. That's not to say that it's not coming. And that's just because it takes time to do it right. You have to, as the APA states, you have to, have a reasoned explanation when you want to change an established policy. And so, although I have no doubt that there are additional rulemakings coming, I don't believe we've seen that quite yet. The second myth that I heard this morning, and that I've certainly heard as I was the general counsel of the Office of Management and Budget for the last 2 years of the Obama administration, is that the Obama administration wasn't focused on eliminating unnecessary regulations. And certainly this administration has been very clear that that's a high priority. And frankly, we would have agreed that it's necessary to eliminate, unnecessary regs. And in fact, President Obama directed in 2011 a retrospective review, which did focus on eliminating unnecessary and wasteful regulations. And that resulted in some progress. Primarily, over the course of the number of years, it resulted in about $37 billion in savings and reduced paperwork. There was one rule, for example, that there were actually 70 notable rules that were removed during that process, and over 800 retrospective review initiatives that took place during that time period. So that's the second myth. I would say the third myth is that the Obama-era rules were incredibly costly. And I guess if you, think about it in the way that the 2 out, 1 in executive order thinks about rules, which is you only think about the costs, but you don't think about the benefits, then perhaps you would draw the conclusion that they were costly. But if you look at the OMB's recent report on cost benefit, you'll see that even the most conservative estimates suggests that although in 2015 dollars the costs were somewhere between $78 to $115 billion for the last 10 years, so that included the entire Obama-era rulemaking process. The benefits for those same rules were somewhere between $287 and $911 billion. So in that sense, the public benefits are well in excess of the costs. And again, from our perspective, it's really important to think about not just the costs as the 2 out, 1 in rule suggests we should do, but again, to think about the benefits and to make rules that are as efficient and as effective as possible. The last, because the judge promised that we had to stay to 5 minutes, I'm sort of blowing through these myths, but the last myth, and one that I heard this morning from the administrator, was, that guidance, that there were she suggested that sub-regulatory guidance was a backdoor to policymaking. And again, there's no real difference of opinion here with respect to the use of guidance. And so I think it's been a myth that in the previous administration, there was some tendency to use guidance in a way that would circumvent rulemaking. That's not the case. And in fact, the Obama administration relied heavily, relied as its own, relied on the good guidance bulletin that was put in place by the Bush administration, in fact, in 2007. And so we used the Good Guidance Bulletin, which specifically dictated that, guidance should only be used to clarify how an agency will interpret the law. It should not make new or impose new requirements. And so all the guidances that did come through OMB, which were required, certain guidances, of course, are required to come through OMB for review. And for those guidances, there was a very clear articulation at each of the top of the guidances that specifically said that it would not add requirements or create new law.
With that kind of last sentence, you've now going 1 minute over.
Oh, darn. Okay, well, then I will conclude and pass it on.
And my rule is not really guidance.
My apologies, Judge.
Mr. Croley.
Thank you. I'm going to I'll save for questions a kind of back and forth debate. I want to just kind of set the table conceptually, if I may. I take the topic at hand to be the mechanics of regulatory reform. So I want to speak to those mechanics. First, I think there are two flavors. One is of regulatory reform. I'm going to focus on mechanics. Two flavors of regulatory reform. One is a kind of good government. So these are policy neutral reforms designed to make government and the executive branch in particular faster, stronger, leaner. And then there are policy pregnant regulatory reforms. These are techniques or tools to undo what a previous administration did, mindful of the substance. They're not policy neutral. And I think again, I'm going to blow through my remarks quickly here too, and we can circle back. I think it's fair to say all recent administrations have engaged in both of these flavors to some extent. The regulatory look back that Ilona referenced was an example of good government regulatory reform. But I'm going to focus here on policy, on regulatory reform with a policy content. And so the question on the table is, how is it that the administration today, whatever administration that is, can unwind the regulatory decisions made by its predecessor administration? Okay, so now to mechanics. I think, again, it's fair to say there are four broad sets of tools that an executive branch has: personnel, budget, inaction, and action. And if of these, I think two are especially potent because they do not require cooperation or supervision by the other branches. The budget does, because a president can introduce a budget, and this current president has, with regulatory policy aims, but unless it is passed in a form that resembles the proposal, it will not be efficacious. Personnel, on the other hand, is something that requires very little supervision or participation by the other branches. Of course, the Senate is involved for key personnel, but by and large, the president can field the team. Inaction, and here's where I want to get to the thesis for discussion, and I want to articulate a thesis for the group and also pose a question, if I may. I think inaction is largely, but not completely, unsupervised by the other branches, insofar as many forms or species of executive inaction are not accompanied by judicial review. Executive action, on the other hand, affirmative measures to undo the previous administration's regulatory agenda, is usually, but not always, but usually susceptible to judicial review. And so I think what we're seeing historically is a gravitational pull towards inaction and increasingly informal subspecies of action, so interpretive rules, guidances, abandoning litigation positions, pulling out of ongoing initiatives. On the part of the current administration. That's not a critique of the current administration. I mean to be making a historical claim. So let me be a little bit more precise about that. I think there are three reasons why we see this bloated currency of informal action and inaction by the executive branch. One is it's just easier. And so there's a certain gravitational pull towards what is easy. One is often these informal steps are taken specifically to undo the previous regime's informal steps. So administration one has a guidance, administration two uses a guidance to undo the guidance. Administration 1 has an executive order. Administration 2 uses an executive order to undo the executive order. So there's a certain kind of reciprocity, if you will. And third, I think there's increasing reliance on informal executive branch tools in the absence of an active legislative branch, because increasingly we see governance achieved by the executive branch rather than the Congress. And again, this isn't a unified, executive theory or anything. It's just a descriptive claim that in a world where there is, by historical standards, fairly little legislation, we see this administration and the past administration taking steps that implement its policy vision on firearms, on immigration, on climate, in one direction or another. Okay, so to my corollary and the punchline, and let me put it succinctly. I think, given these trends, if I'm right as a descriptive matter, one thing follows about judicial review, and that is that the arbitrary and capricious test, the one and only hook that the judiciary really has on these informal species of executive action, is what stands between us and madness. That is, without some possibility of a judicial check, the light touch of arbitrary and capricious, we would see, for the reasons that I've described, executive branches, this and future and past, able to use informal actions and inactions without any oversight or participation by the other branches, and probably that would be an undesirable thing.
Thank you very much. Jeff Harris?
Sure. Thank you to the Federalist Society for having me and to my co-panelists. I would just reiterate that I did leave OMB 2 weeks ago and will be going back to the private sector, so I'm only speaking as a private citizen, not on behalf of anyone in the government. So I think in terms of the mechanics of regulatory reform, which is the topic of this panel, the regulatory budget that this administration has been working on is really a pretty profound achievement. So Executive Order 13771 was issued on January 30th of last year, just 10 days after the inauguration, and this is commonly known as the one-in, two-out rule. So for every new regulation promulgated, an agency needs to repeal or withdraw 2 existing regulations. And I think a lot of folks, even on the right or sort of proponents of a more conservative approach to regulation, dismiss this as just a gimmick, or it's silly, or it's just trying to grab headlines. But I think it's fair to say that almost a year and a half in, the regulatory budget is actually working. And this is something that people have been talking about and thinking about, including co-panelist Jeff Rosen have been thinking about for years. And I think we now have something that could be an effective and durable regulatory budget for the first time ever. And I think many observers will focus only on the one-in, two-out aspect, but the other piece is arguably even more consequential, which said not only does an agency have to do sort of the numbers, but they also have to ensure for 2017 that new net regulatory costs are at or below 0. And then for 2018, the administration actually flipped those numbers to negative and expected every agency to have a net reduction in cost savings. Now, I think the 2 provisions actually work really well together, because the one-in, two-out rule is good for things like cleanup, so for guidances, information collections, regs that have been overtaken by events or that have been displaced by statute. It really incentivizes the agency to kind of clean that stuff up. But the budget, or the numerical budget, is almost even more powerful, because that's saying if you're looking at something that's going to be a big coster on the private sector, you simultaneously need to be thinking about what you'll be doing to lift burdens in other areas. So it's really, I think, the 2 pieces, and the second one I think gets lost in some of the popular narrative, really work well together. And I think this is all working. So for fiscal year 2017, which ended on February 20th, the federal government had 22 deregulatory actions for every 1 regulatory action, and net regulatory cost savings of $8 billion in present value. And I completely agree with Ilona. A lot of those cost savings are attributable to delays or, sort of delays, postponements, rather than sort of final rules. But that's the nature of the rulemaking process. I mean, I think to go from, a fully staffed agency to an NPRM to a public comment period to a final rule, there just weren't a lot of those that had been sort of fully completed. So although many of those are sort of delay type rules, I do think the number is real. And it's not just the old Washington trick of slowing the rate of growth and calling it a decrease. Those are actually real decreases in regulatory costs. So in terms of where we go next on regulatory budgeting, I think I would love to personally see some legislation that formalizes this and, either puts it in statute or syncs up the regulatory budget with the actual budget, which would be great, but in a 60-vote Senate, that's probably not especially realistic. But I think one thing that's happening right now, which could be sort of a game changer in all of this, is there's some really interesting work being done by Mercatus and others about cumulative regulatory burdens. So 13771 is really dealing with sort of the income statement or the flow of new regulations. But if there were some good estimates of the cumulative regulatory burden, that starts to look like a balance sheet. And so then I think it could sort of really move the ball in terms of changing the conversation of how agencies look at retrospective review and look at where the biggest burdens are. But that's a massively complicated problem, and I hope that it is solved, but that's probably a 5 to 10 year thing instead of a 1 to 3 year thing. The last thing I'll say, I think I have 2 minutes left, is...
You have 1 minute left.
I have 1 minute left. So because it's tax day, I think there was a tremendous breakthrough last week in the terms of the process for making new tax regulations. For decades, Treasury had been taking the position that its tax regulations don't go through OIRA, don't go through White House clearance, don't go through OMB, because they're just applying statutes or interpreting statutes rather than making policy. And lots of observers on the Hill, outside parties, nonprofit groups, criticized this and said, no, of course you're exercising discretion in making policy. And kudos to Brent McIntosh, another former clerk of the judges, and Naomi Rao, who just reached a new agreement which will do fast-track OIRA review of tax regulations, which is just tremendous, I think, for good government and for the regulatory process, because it's going to ensure that there's another independent check that might be putting the brakes on some excesses of the IRS. So good development for tax day.
But I'm sure Brent McIntosh has an entirely different view of your position on that question. But when two of my law clerks fight with each other, I am absolutely neutral. Jeffrey Rosen.
Well, first, I'm pleased to be here, and let me thank the judge and the distinguished panelists that I'm with and the Federalist Society for having us. In talking about regulatory reform, I like to start with the stock of what we're dealing with. So many of you are probably aware, but sometimes don't get a chance to reflect on, the Code of Federal Regulations as it currently stands is 242 volumes. It's 185,000 pages. And if you could devote full time to reading it and do nothing else, it would take you 3 years. So it's a lot. In the Department of Transportation, where I am now, we have about 25 of those volumes. I have just an illustration. It's a lot of books. And so we're about 10% of the stock of regulation. And so we start with the issue of, everybody agrees some regulation is needed. We're really talking about how much is enough and when is there too much cost. So in thinking about the steps for regulatory reform, there are really 4 that I want to just quickly touch on. One is a somewhat obvious one that each administration does at the beginning, and that's stop the growth, put a hold or a freeze, and that's become a routine step over the years. But it's an important one in that at transportation, at least, according to Federal Register notices over the last decade, new regulations were adding about $3 billion a year of new incremental costs. So the first thing, if you're trying to start a regulatory reform effort, is stop that. Don't grow $3 billion a year of new incremental costs. Second step is deal with the carryover rules, the so-called midnight rules that every administration that's incoming gets to deal with. That takes some time, but we've dealt with that, and I think other agencies have. But then step 3, and this is the one I actually want to focus on, is the Executive Order 13771 that deals with controlling regulatory costs, or sometimes called the Regulatory Budget Executive Order, fundamentally changes the way an agency is managed and the way that rulemaking is conducted. And why is that? Because now you take the regulatory agenda, so-called unified regulatory agenda that has been going on for decades, and it's not just a list of what people chose to be working on. It's now a systematic effort to figure out how do we comply with the overall balance that the number of incoming new regulations is going to be offset in terms of the costs by old regulations, and that for each one in, there's 2 out. So that can't just happen as a one-off or one at a time. You have to be thinking ahead the whole time, and the cultural approach to regulation changes as you, twice a year, when the regulatory agenda is submitted to OMB and then issued, think, does this add up? Or do we have the 2 outs for the 1-ins? Do we have the regulatory cost savings for those places where there are new rules either required by Congress or as exercises of discretion? And that's very different than I think it's been done in the past. The regulatory agenda now becomes an actual planning tool for what rules do we need and how are we going to achieve the savings that are needed. And does this now mean that that stock of those 25 volumes isn't going to get bigger? If anything, it's going to shrink, or at least 1 in, 2 out should produce fewer pages. And so that's a really key step. After that, it's the ordinary blocking and tackling that all agencies have to do of the notice and comment process, responding to comments, doing sensible analysis, doing the regulatory evaluations and cost benefit, and so on, to execute on the agenda that's been planned. And then the 4th step that I just quickly touch on is a corollary, which is once you've got a regulatory agenda, is it the agenda, or can it be circumvented by guidance or other regulatory tools? And so in our case, and I think other agencies as well, we're taking steps to ensure that the OMB Bulletin on Good Guidance Practices, for example, is adhered to, that significant guidance is itself subjected to notice and comment, and goes through similar process to regulation itself. So I just flagged those as steps in the regulatory process, because by doing these things, the costs are controlled, the volume is controlled, but the regulation that's necessary and appropriate is accomplished, maintained, and improved upon. Better results at lower costs. And that's fundamentally what we want out of the regulatory system.
Thank you. Well, let me ask a couple of questions and then throw it open to the audience. Number 1, how do you determine whether a guidance is a de facto regulation or not? A question, of course, which occupies the attention of appellate judges. But how do you do it? How did you do it under the Obama administration? And how do you do it under the Trump administration?
Well, we really were governed by the Bulletin on Good Guidance Practices, which, as I mentioned, dates back to 2007. And in that document, if I remember it correctly, it states that, the intent of the guidance is to increase efficiency, to provide the public clear notice of the line between permissible and impermissible conduct, and ensure equal treatment among similarly situated persons. The goal of the guidance, and again at the top of each guidance that at least came through OMB for review, it specifically states that the goal is not to add requirements to applicable law, and it will not create or confer any new rights. on any person. And so we would take that standard and apply it to the document before.
Excuse me, did you assume that was not reviewable?
Did I assume that that was not reviewable? I'm not sure we made that assumption, but we certainly would try our best to adhere to that standard.
To make sure that it was not reviewable?
No, we would try our best to adhere to that standard. I didn't personally think about.
You didn't ask your question whether it was reviewable or not?
I did not. I mean, I thought I looked at the standard in front of us and did our best to try to apply that. And
What about the rest of you with respect to guidance? Isn't that a normal problem? Also, how do you treat guidance as your 2-to-1? Is that for those of you who are bragging about 2-to-1?
Well, Jeff may be able to address it government-wide, but from my standpoint, guidance doesn't count on the 2-for-1. That guidance is not supposed to be binding regulation. So if you change it, you haven't changed an actual regulation. But I don't know if OIRA looked at that differently government-wide. I don't think so.
I think they did in an attempt to ensure that, that agencies were incentivized to do sort of meaningful retrospective review. OIRA took the position, which is public, that if you repeal some guidances, you can get outs under 2-for-1, so it can be treated as one of the 2 removed things. But unless the agency quantified the estimated cost of what it was imposing, that wouldn't count against the reg budget.
What about reviewability? Did any of you consider that with respect to guidance? No? Any of you? The silence is deafening.
Well,
I'm
it's
happy
almost
to
too
tell you.
abstract a question in a sense,
so
right?
So let me answer your first question, Judge, on the difference, which is something that the judiciary struggles with. And my view is it will always struggle with it, and that is because it's not a dichotomy, it's a spectrum, right? It's like for my kids, there's such a thing as a recommendation and such a thing as a command, but there's stuff there in the middle, inevitably. And so there are earmarks of informality and earmarks of heavily prescriptive, but there are also statements that emanate from agencies that have a flavor of both. And so I don't think that, I'm just making a conceptual claim, I don't think that there is a bright line. It's not that no one's been smart enough on the semantics.
I
Yes.
agree with you on that. But do you think about that did you think about that when you were issuing
Sure.
guidance?
Yeah, the Energy Department did, sure. If we were calling something a guidance, in other words, in the very decision about how to label something, we would ask the question, would it lend itself to judicial review? And indeed, would parties be incentivized to bring cases challenging it? That would be an earmark of something that would be less likely to be a guidance, yes.
And certainly, even though I'm sure Ilona would know, but I'm sure a number of the guidances in the last administration, when you look at Title IX or some of the education ones or some of the disparate impact ones, a lot of those were challenged, sometimes successfully, even though I'm sure, you took the position that they were guidance and not rules.
sure, I mean, we expected that there would be certain guidances that would be challenged in court, and that turned out to be the case.
Did you adopt those guidance specifically to avoid judicial review?
No, certainly not.
Why, on that most important one on Title IX, did you not issue a regulation?
So that was appropriate for a guidance because they had there were a number of school districts and superintendents and parents and teachers asking for information about how the agencies would interpret Title IX. In light of the Fourth Circuit case, the department was taking the same position in a public reviewable forum in the Fourth Circuit that they were taking in the guidance, and they wanted to lay out their argument in the guidance in order to help folks understand how they would interpret the law.
As I recall, when the case came to our court, the decision was made that nobody had standing because it wasn't brought by any of the universities who were impacted by it. So it avoided judicial review, which I wondered whether that was its purpose from the very beginning.
No, it was not the purpose. The purpose was, again, to explain and to ensure that folks understood the interpretation that they were also taking in other judicial fora.
I see. Now, Ilona and Steve, what are your criticisms of the present administration's deregulatory efforts? Or are you totally in agreement with everything they're doing?
Well, where to begin? I mean, I'm interested in the version of the question about structure, right? And so, picking up on something Jeff said. So I agree with 90% of what he said. I don't know if that surprises you or not. We all want fewer regulations, all else equal. We all want smarter regulations and cheaper regulations.
I'm interested in the 10%.
Okay, so the 10%, like, I don't think much follows from how many volumes of the CFR there are. 25 might be too many, it might be too few. I don't find meaning in that observation. I have studied the Federal Register and the expansion of, so one often heard talking point is pages of the Federal Register have increased over time. That's true. You know why? Because the regulations are more detailed. And from a kind of notice and business notice and transparency point of view, that's a good thing. So I guess I'm not as moved by kind of these absolute numbers, but I am interested in the question, which rules do we not really need? Which rules do we need? I think it's important.
Well, I would just respond. I mean, I think, of course, the numbers are sort of whether 2-for-1 or pages or anything can go out. I mean, I think one of the sort of accomplishments is I do think that hopefully the administration is, promoting sort of certainty and clarity. I mean, I think there was often a sense in the last administration that every industry had sort of an anvil hanging over its head, and whether it's, net neutrality or some of the energy stuff. I mean, it just industry after industry after industry, there were just these major sort of sweeping initiatives. And I think, again, I'm not speaking for anyone in there, but I think it's fair to say that this administration is not looking to fundamentally restructure industries and change the whole MO of their operation, which I think has to promote business confidence when, you're about to make an investment.
Yes. Do you have a point on that, Jeff?
Well, I always like the points of agreement, and so the reference to the Good Guidance Bulletin was one I welcomed because I was general counsel of OMB and worked on that one. And I have felt that it hasn't got the full attention that it deserves in the public realm in that I think there are very succinct but useful requirements in that bulletin, and including that guidance be labeled as guidance and that significant guidance be subjected to public comment, even if it's after the fact rather than before the fact sometimes. And so I think that may be a point of agreement among us that can sometimes be useful because I think that bulletin deserves more attention than it sometimes gets.
I have one question for you, Jeff Harris. As you go through the 2-to-1 process, aren't you going to run out of the low-hanging fruit in a year or so, and then it's going to be much more difficult? The low-hanging fruit, of course, is the regulations which are no longer of any significance to anybody, so eliminating them has no impact. That's what I'm talking about is low-hanging fruit. After a while, you're going to start getting into muscle, aren't you?
No, that's a terrific question. And I think, even a lot of the energy at the agencies has been spent on, sort of undoing some of these 2015, 2016 rules that weren't covered by the CRA. And that's still, I think those are still very much ongoing processes. And so even 4 years sounds like a long time, but I think there's just such a long lead time of even just trying to reform some of the big ticket items at the end of the last administration. I think after those, you're absolutely right that then you start to wonder where else are these big savings going to come from. But there is a surprisingly long lead time, which even sort of knowing about how the process worked a little bit, it's pretty substantial.
Well, perhaps I ought to throw it open to questions. I'm not getting any disagreement amongst this group. It's very disappointing. So I'm sure somebody in the audience will provide some yeast. Does anybody have any questions? Yes, sir.
Yeah, I am particularly interested that we have the Deputy Secretary of Transportation here. And there's a lot of exciting things that are happening. I come from the New York City, Long Island region, and there's this one bridge called the Goethals Bridge. And apparently it took about 10 years to get all the permits put together in order to allow the Port Authority of New York and New Jersey to commence construction on basically tearing down a derelict bridge with unsafe safety conditions, and to replace it with something that's modern. Now, the Department of Transportation is at the forefront of simplifying regulations, but also you're working with other agencies under the Trump administration to work together so that the EPA permits, maybe the Coast Guard permits, and many other things that are involved can also be resolved quickly and rapidly. I should mention that having compared infrastructure costs across the world, the United States basically spends much more on transportation projects than even Switzerland. And you think of Switzerland as a high-price country, but to build a tunnel here costs far more than it does in Switzerland. So I'm really interested in, maybe you could elaborate further on this issue. It's much more than just 2 for 1. Thank you.
So that's a good point, that a part of regulatory reform for us has been permit reform, and they're not identical, but they're intersecting, because there's a lot of rules that have to be required, compliance with which is required in order to get permits. And in the federal government, that's been a challenging and sometimes Byzantine process, very complicated, multiple agencies. For us, as someone who's often funding infrastructure projects, there's intersections with EPA, with the Army Corps of Engineers, with the Interior Department, especially Fish and Wildlife. And there's been a big effort, and just last week was a new MOU among large number of agencies to have one federal decision so that the reviews are done concurrently, and there's a lead agency that can set the timetables, and if they're not met, step into the shoes to make things happen. And did you say it was 10 years? Was that the Bayonne Bridge?
10 years for, that was for the Watkins Bridge.
Okay. And, we aim to dramatically improve that situation, and I think we're making headway, but it's a constant need for attention, because inaction can be a problem, the deadlines slip. So that is an area of real focus for us and the administration more generally.
Yes, sir.
Yes, my question also for Jeffrey.
Perhaps you should identify yourself.
Yes, I'm Jim Calderwood with the law firm of Zuckert, Scout and Rassenberger. Okay, for Jeffrey Rosen, on the 1-in, 2-out rule for new regulations, how does it work at DOT and other departments? That is, let's say the Federal Highway Administration wanted to come out with a new regulation. Could you eliminate an FAA regulation and a Federal Maritime Administration regulation, both agencies also part of DOT, as is Federal Highway, and fulfill the 2-out part of the rule?
So the answer is it's done at the department level, so we can count the 2 out, the more deregulatory steps, from the way you just outlined it, that we could count a federal highway rule that we're getting out as an offset to a rule that another agency, let's just say NHTSA, was doing. But we aim in the first instance to have everybody do them within the agencies. We have 9 agencies within DOT. Mm-hmm. We aim to have everybody comply, but in the planning process, we then do some smoothing, let's say, with the idea that somebody may owe one later, that if NHTSA is doing a rule and they're going to get an offset from somebody else, they're going to owe that in the planning process. So I don't think OIRA actually requires it. I think they're at the departmental level, but we want to kind of keep those relatively balanced over time. If we can't, sometimes there's some regulations that are unusually large or consequential, then we may just have to deal with it. But so the answer is, as a formal matter, it's at the department level, and we could use and can use offsets that are not from the sub-agency whose rule it is that's the 1-in.
Okay, thank you.
Mr. Gerson.
Stuart Gerson. With an eye on the False Claims Act and healthcare fraud, the Attorney General recently instructed the lawyers of the Justice Department that guidance may not be used in order to attempt to establish the elements of substantive offenses. One would argue that that's the law anyway, but what does the panel think of that, and how in the previous administration might that kind of a thing be greeted?
I'll just say quickly that I think there were 2 memoranda in the Justice Department on guidance documents and what's the impact in enforcement and then more generally. And they seemed largely to be a restatement of the law, but a very useful restatement in that they were succinct and clear guidance on guidance.
Yeah, I would agree with that I think they're largely restatement. I'm not sure really what the impact might be, frankly, because if you're saying, I think Associate Attorney General Brand issued a memo that specifically said that we weren't going to rely on guidance for enforcement, but really what she's saying is if the guidance is properly issued and is just a way that describes how an agency is planning to interpret the law, you actually don't need to rely on guidance. You just have the agency's interpretation of the law. And so I'm not sure that it adds.
Well, as a matter of law, you couldn't rely on the guidance as independent of the underlying.
Sure, that, of course, but you can still rely on the agency's still entitled to rely on its own interpretation of the law, which will ultimately be the same.
And I think it's helpful too, atmospherically. I mean, the False Claims Act was the second one, but the first one was talking about guidance issued from components within DOJ, which it's often helpful to get these reminders. There are a lot of components and subcomponents throughout the government that just seem to think because we've always done it this way, we can keep doing it this way, even if they're pretty much operating through guidance instead of regs.
Yes, sir.
Victor Schwartz, Shapari and Bacon. I want to build on a question that the judge asked earlier. Do you see a time when the 2-for-1 rule has done its job? The way some people talk about affirmative action, that it's no longer necessary. And if so, what would the criteria be when we've had enough of 2-to-1?
I'm happy to take that one first, which is I don't see a time when it ceases to apply. It seems to me that the real point of the 2-for-1 is to have a budgeting concept apply to the regulatory apparatus in the same way it does to the fiscal apparatus. And so it's much more about both the planning requirements and the culture of thinking about how to allocate resources as a whole different way of thinking about regulation. And I don't think that is ever going to expire. I think it should be, is and ought to be a permanent feature of how regulation is done in the same way that that's how the fiscal budgeting works. Is we don't reach a point where we say we saved enough money, we're done. We don't need to prioritize, we don't need to budget anymore. There will always be a need to do better. And the analogy that I regularly use with this is in the private sector, a company says, our goal is on the one hand to increase revenues and on the other hand to decrease costs. And there doesn't come a point where they say, we only want to increase revenues, we're done controlling our costs. So in the regulatory realm, we want to improve regulatory outcomes, whether that's safety or health outcomes or consumer protection or whatever it is, improve the outcomes while perpetually looking for ways to do it better, more efficiently at lower costs. And I don't think there ever comes a point where we say, it's perfect, because it would be wonderful if we got there, but I don't know of a human endeavor that we reach a point that we can actually say it's perfect for the rest of history.
Well, it's 2-for-1, rather artificial. Suppose you eliminate 2 regulations that are of trivial cost in return for adding a regulation that has monstrous cost. That's sort of a meaningless transaction then in terms of deregulation. And was that what Jeff Harris was getting at when he was saying the real key is the budget?
Yes.
Not so much the 2-for-1.
Yeah, that's right. And I think another thing that's sort of relevant of will there ever come a time when it's not necessary? There are lots of areas of new, and especially squarely in Jeff's bailiwick think of drones or autonomous vehicles. At the moment, the commercial use of drones is highly restricted. So if DOT were to expand the conditions in which you could use commercial drones, presumably that's going to include a lot of text in the CFR and the Federal Register, but yet that is enabling the public to do something they couldn't previously do. So there are those situations, and I know OIRA's thinking about how to account for that, but those don't sort of perfectly map on where you're adding reg text in the context of allowing people to more freedom to do what they couldn't do before.
Yeah, wait a minute, did I see a question? Yes, yes, sir.
Wayne Simmons with State Farm. I'm wondering if you could describe some of the processes for sort of determining the scope of your legislative authority in rulemaking. On one end, it could be a real rigorous analysis of where you think your authorities are. And on the other end, it could be something like the fiduciary rule where the client wants a result. So come up with an argument and hopefully we get Chevron deference. And, you know, the fiduciary rule was just struck down by this sort. So just describe what processes you go through, just even to determine the scope of your authorities. That'd be curious to know.
Well, that's a big question.
Yeah.
So let me take it. I mean, so neither of those exactly, and maybe somewhere in between. I think the realistic observation is that, let me speak to my experience at the Department of Energy. So much of our rulemaking, such as it was we weren't starting from scratch. So we were continuing a regulatory program pursuant to statutes passed in administrations long before ours, and sometimes maybe with a statutory deadline or a statutory obligation with or without a calendar deadline. It's not like we thought, sat around the room and said, what new rule can we think of, or what think of an area where we need a rule making. Inertia is what I'm trying to capture, was kind of set the agenda for us in 90% of the cases. Now, sometimes we would get interest groups or stakeholder groups to come and say, would you make a modification of a rule or revisit an old rulemaking because it hasn't, it has been imprecise or it has imposed costs on us. And there we would think a little bit creatively. The fiduciary duty wasn't so much to the Secretary of Energy necessarily, but to, the taxpayer, the citizen of the United States. And so we would have a serious discussion to do something, more or less new. But I guess the answer to your question is somewhere in between there.
Anybody else have a comment on that? How do the panelists feel about Chevron, which is now, at least in some circles, under criticism that didn't exist before?
So I think that, I hope it's not getting too much of a bad rap. I think that I think that there's a serious difference between sort of the framework and whether courts are applying it right, and I think those can get blurred often. I think that a lot of things that conservatives viewed as overreach in the last administration are just wrong readings of the statute, which Chevron or no Chevron are things, it's not necessarily the framework so much as just how do you interpret the statute. So I'll give a mild defense of Chevron. I think it's something that, I think it is a useful framework because there are always going to be, especially when you get into the world of policy, sort of determinations that are ultimately committed to this discretion of the agency. And I think the most important thing is courts that are able to correctly interpret the statute with or without Chevron.
What I think is somewhat interesting and in a way astonishing, there is criticism of the underlying premise of Chevron more and more. The underlying premise of Chevron is that when ambiguities in a statute are created, the reconciliation of those ambiguities is more legitimately done by agencies, whether independent, so-called independent regulatory agencies or executive branch agencies, because they have greater political legitimacy in reconciling those ambiguities than federal judges do. That was the underlying premise of Chevron. And now I see in conservative circles some attack on that premise. How do you all feel about it? You think the premise is still correct? Anybody?
Yes, with a caveat. I think the premise.
I know. I could have known you clerked for Steve Wiggins.
I was trained well. Yes. Yeah. It's democratic legitimacy when ambiguity was the method of delegating, right? Not raw ambiguity, not utter ambiguity, because that, or let me just take the position, that would be the domain of the judiciary to resolve ambiguities. It was, as I read Chevron, as I understand Chevron to be understood, it's ambiguity as a means of delegating to an agency.
Nino Scalia used to say, I think correctly, that it's the background rule. It doesn't really reflect an intent to delegate, but it's the background rule that Congress knows. And if they screw up and write in general terms, they're giving the delegation to the agency, whether they intended or not.
And I would just add one more note. You know, Judge Kavanaugh has written about this as well. I mean, I think Chevron looks a lot, to me at least, like the tiers of scrutiny under some of the First Amendment and 14th Amendment. And that's all just sort of an artificial thing that the courts made up to help them adjudicate cases. And I hope, and I think the courts are moving in this direction where you'll see them just on a question, if it's a pure question of law. I mean, again, it's one thing if it says, protect the public with an adequate margin of safety. Well, what is adequate? That's a factual determination deferred to the agency. But if the question is, does this apply to mobile sources or not? That's a question of law, which the court can interpret without this sort of crutch of Chevron. And so, you know, I think we're hopefully going to evolve into a world where on pure questions of law about what does the statute mean, courts just do it without having to go through this sort of artificial exercise, just as I hope they're moving that direction in the First Amendment and some other areas.
I think that's wrong, but what can I do? Anybody else have a view about that? I think to a certain extent, the last two administrations have abused Chevron. Chevron was designed to deal with a situation where there's an ambiguity in a statute, and it could be legitimately interpreted either A or B. A good lawyer looking at it would advise his client, you know what, I don't know for sure. This could go either A or B. I don't know. And that was the classic case where the agency's determination was entitled to deference. But what I saw increasingly happen is a general counsel would tell his boss, this statute is ambiguous. To be sure, it's ambiguous as between A and B, but that's not really helpful to us. We want to do X. So let's do X and say it's reconciliation of the ambiguity. And that ignored this, and some of the courts have ignored the second step of Chevron, which is, yeah, this is ambiguous, but it's an unreasonable interpretation. I have written recently about that. And Justice Scalia increasingly came to the view that the second step of Chevron had a lot more muscle than originally was given. But that's, you know, here's a judge talking. You know, what the hell do I know? Yes, sir.
Mark Chenoweth, New Civil Liberties Alliance. Ms. Cohen referenced the brand memo that DOJ put out, I think at the end of January, announcing that they were not going to use their civil enforcement authority in the future to enforce guidance from any of the, I take it from any of the other agencies, not just DOJ. Should that be done as a rule? I found it sort of curious. It should have been done as a guidance.
Interesting question.
That is an interesting question.
Elena, are you going to take that?
Yeah, I mean,
in other words, was it illegitimate to do? I think your question was that illegitimate to do as a statement. Should it have been done through notice and comment? Is that your question?
That's right, or would it at least be more permanent if it were done that way instead of just as an announced policy?
I think my position earlier was that I didn't think it had, I mean, it's helpful to the extent that you have an agency that, you know, sharing their views, but my view earlier was that I didn't think it had much of an impact. So I think it was appropriate to do as a guidance. I don't know, Jeff, if you have a different view or.
Yeah, I don't think, I mean, the permanence question aside, I don't think anyone could seriously say that this, I mean, I think the good rule of thumb for guidance is it doing something new in a way that, you know, could be seen as binding the public? And I don't think there's any suggestion that, you know, this was a rampant issue of, you know, everyone viewed it as just fine to sort of enforce guidance against, you know, through the False Claims Act, and then this stopped that. I mean, so I think it was more sort of codifying what the agency had been doing, which does seem like an appropriate use of the guidance tool.
I'm not sure it was actually a guidance. Like, did it specifically state that it was a guidance, or was it just a memo that was, yeah?
A memo indicating, I guess a memo indicating what guidance should and should not mean.
But it wasn't a guidance in the way that the OMB would use the term, in the way that it would be defined under the Good Guidance Bulletin, for example. And it certainly wasn't significant, so it wouldn't have gone through OMB's review.
Do you have a point on that?
I just have a cousin example that might be helpful. So if you could contrast that with the Attorney General's memorandum on marijuana. So whereas the guidance that we're talking about, you could say roughly protects the public in a sense, right? Those who would be the focus of, investigations. And this is the inverse. It's to put the public back on notice that the administration may move away from its the discretionary position it took in the last administration to focus on gangs and traffickers and not mom and pop operations whose activities violated the Controlled Substances Act. So there would be a case, to your point maybe, where I'm not suggesting that had to be a rule, but because it was not protective of the public in the way that the guidance that we're talking about was, it'd be a more interesting case for more robust process.
Mr. Gerson.
I would argue that it shouldn't be subject to rulemaking because the change merely enforces the law. There's nothing for the public to state a negative view about. However, Mr. Harris, you're entirely wrong that it's inconsequential. I mean, for many years, the Department of Health and Human Services, through FDA and CMS and the Inspector General, have been arguing guidance in False Claims Act cases. This should be a material change in policy.
Any other questions out? Yes, sir.
Nathan Murray. We've been, with respect to the mechanics of reform, we've been discussing focusing on efficiency, fewer, smarter, cheaper, and that's important. But what are the mechanics of getting the regulators and the rule makers, before they do anything else, to consider, is this rule just? How, not just considering just the costs, but the consequences to liberty, and also accountability to the people who this regulation is going to put at risk.
This regulation is going to what?
The people who this regulation is going to put at risk. The people who are going to have to suffer the consequences of the outcomes or penalties for violating a rule that is now being passed.
Well, don't you also have to consider the beneficiaries of the regulation?
Yes, but also the people who are being affected by it. Should the what would be the mechanics of improving the regulatory mindset, I guess, or process to ensure that when a regulation is passed, it's not just because it's efficient or because this is something we can do. Is this something we should do? Is it the right thing?
Oh, no, that's not fair to ask the government to do that. That's too much of a burden. Does anybody else have any comment on that?
Well, that's the purpose of the notice
Yes,
and comment
of course.
rulemaking process, right? And the reason why it's so important and why, as much time is given to the public's comments so that you can fully understand and incorporate those views into the final product.
Presumably, no agency at any time issues a proposed rule without some conviction that what they're doing is good, more good than bad. There may be disagreements. Reasonable men and women may differ on that, but I can't imagine any agency issuing a rule for the deliberate purpose of hurting people.
Well, I would suggest that.
And you can build it in centrally. So recent executive orders say to consider the distributive consequences
Yes.
of rulemaking and so forth. I mean, at the OIRA stage.
Yes, ma'am.
Carolyn White, I'm with the Air Force General Counsel's office. I'd like to delve a little more into the mechanics and how does one get to smart review in the reform. And I say that because honestly, the push within our agency, and most of our regulations are internal, don't affect the public. They're issuances that, they're not subject to notice and comment rulemaking. The focus seems to be very much on length, without really having a framework of what kind of questions and factors we look at in decrease. And I'll give you a concrete example that I saw in the last 3 days, where one of our few regulations is actually in CFR is being proposed to be eliminated. It's civil administration of Wake Island. Well, there's no public access to Wake Island whatsoever. I don't think there's any public burden associated with the rules whatsoever, unless one counts that the mere presence of 2 pages in CFR counts as a burden somehow. So how do we get to smart review?
Well, let me ask you the question. What's the advantage of this regulation dealing with Wake Island?
It sets up federal employees or government contractors in support of military operations.
So you think the regulation is necessary, otherwise there's chaos?
Well, otherwise you have no formal, I guess you could do it via some sort of formal delegation memo from the president, but that doesn't exist, and then you're just replacing one piece of paper with another.
And I, there is the significance determination process in OIRA. So OIRA only reviews significant regulations, which are obviously legal or policy significant, have more than $100 million impact. And so I don't want to comment on that particular one, but that seems like one a reasonable observer might infer would not be significant necessarily.
It's not. None of the ones that I would be looking at, or frankly that most of the Air Force is looking at the moment, I would rise to the level of significance. But it does seem to be very much there's a push to decrease pages without a framework of how does one think about what constitutes the decrease, why do we decrease, what are the questions we should be asking, how does one get to the smart review? I guess that's what I'm really asking.
You have to hire smart people. That's not all that easy. Does anybody have, yes, sir.
Hi, Greg Jacob of O'Melveny and Myers, formerly Solicitor of Labor, the other former Solicitor of Labor in the room. My question.
I'm a former everything.
It seems to me that we are increasingly barreling towards a world in which there is the Republican set of guidance documents and the Democratic set of guidance documents on several issues that say completely opposite things, opposite interpretations of them. And I think we've seen the courts reacting to that by saying, we're not going to defer to these last-minute switches of interpretation in guidance documents. So my question is, does it make sense to use notice and comment rulemaking to try to lock in an interpretation? And if so, should those perhaps liberty-emphasizing regulations that lock in a Republican interpretation count as a regulation that you have to eliminate too in order to do that good work of locking in a helpful interpretation?
Are you suggesting that the OIRA should police this and say that the two that you have to get rid of are all regulations that were issued under Democratic administrations?
Well, no, I'm not suggesting that you should
Aren't you coming close to saying that?
No, but I think it's simply a reality that as you look at the behavior, this is true. This has long been true of executive orders, right? You get switches back and forth. If a Republican administration comes in, you get this executive order. Democratic administration says the complete opposite. But at least looking at my old agency, the Labor Department, I see the same thing in opinion letters, whether you're doing opinion letters, certain guidance bulletins and things. And so not necessarily looking at what administration did them, but if you look at, does it make sense to try to lock in?
I'm not sure I understand what you would do that is being, what you would not do that is being done.
The question is, does it make sense to try to use notice and comment rulemaking? The question was asked, for example, before. Should the guidance document that was put out, or the memo about guidance documents put out by Rachel, should she have done that through notice and comment rulemaking instead? It would have been better to lock that in through a notice and comment rulemaking. So my question is notice and comment rulemaking one way to end the sort of tit for tat on guidance documents where they're so easily switched out back and forth? Lock it in as an interpretive regulation that then can only be undone through notice and comment rulemaking, thus warranting more judicial deference on the one hand, and on the other hand, fostering increased transparency in this war of guidance that I see increasingly developing as administrations march on. Does that make more sense?
Anybody, I understand your question. I have my view, but let's turn to the members of the panel.
I don't think all guidance is appropriate for notice and comment rulemaking. And in fact, I think, I went from being the general counsel of OMB to being the general counsel of a healthcare company that is, obviously very heavily regulated. And I think if you took away from agencies the ability to provide, the ability to lay out their thinking in a guidance document, that could actually potentially hurt businesses because, say what you will about the Title IX guidance, but in fact that was issued in response to just an outpouring of questions that was coming from, like I said, superintendents, principals, et cetera, school officials who really wanted to know where does the Department of Education, the Department of Justice stand on this particular matter. And so if you had to wait until the notice and comment rulemaking for that guidance to be issued, it would be substantially delayed. And so again, where the guidance bulletin stipulates that guidance is appropriate, I think that you should continue to be able to issue guidance in order to provide that clarity for businesses and others who are seeking that information.
There's an inevitable tension between an agency's desire to let the regulated class know the direction of their thinking with respect to the enforcement of a regulation or a rule or a statute on the one hand, and giving such firm guidance that you've essentially issued a regulation without going through notice and comment. And there's a natural tension there that comes up. The wise general counsel will issue guidance in such a tentative way that he or she won't be challenged as issuing a regulation without notice and comment. Recognizing that the more loosey-goosey the guidance is, the less direction it gives to the regulated class. But the more firm it is, the more you've got a reviewable regulation masquerading as guidance. Is that correct?
I think that's a fair description. There are guidances, by the way, that do go through notice and comment rulemaking, and again, the bulletin stipulates which guidances those are. So it's not that all guidances, avoid that process. It's just that there are certain ones that have less of a substantial or less of an economic benefit that do not. And again, that's helpful, I think, to businesses. Speaking from a very heavily regulated business, it's helpful to be able to have that laid out in a guidance in a timely way.
And if I could briefly follow up. So I guess my question, to put a finer point on it, is this. Are there instances where, I'm not saying that you should stop doing guidance documents, but are there instances where it's good government to take something that is a warring position that's going to flip back and forth in guidance documents, and instead to go through a notice and comment rulemaking process on it in order to lock in?
It's not going to lock in, though. It can be revoked by a new administration through notice and comment.
Through notice and comment, a more transparent process where people have more input, they know that it's coming, it's not the sort of thing that comes in day one. And is 2-for-1 an obstacle to doing a good regulation that creates perhaps a more transparent process in those instances where, for example, independent contractor, we flipped back and forth now twice on the government's view of what constitutes an independent contractor. Would it be useful to lock that in a reg, and is 2-for-1 an obstacle for doing a good regulation in that regard that otherwise would be a guidance that might later just flip?
Jeff?
I don't think the 2-for-1's an obstacle to that at all. And in fact, how it applies would be somewhat ambiguous because if the new guidance were lightening obligations or removing restrictions in some way, it might count as the 2 rather than the 1. So at least from the outset, it's not clear to me that it has any effect on whether it's a good idea. But I agree with what Judge Silberman was alluding to. On the concept of locking in, I don't really understand how it does that because notice and comment is not that onerous. It can take some time. It takes less time on a guidance than it does on a legislative rule. So it may be good government in the sense that if it's a controversial matter, getting public input can be beneficial, helps people think through their positions, understand vulnerabilities or nuances. It may be a good thing to do in its own way, but I don't see that it necessarily locks things in because things that are done by notice and comment can be undone by notice and comment.
Any further questions? We have time for one more if it's really provocative. Does anybody have a question? Does anybody on the panel want to say anything in response to the questions?
I'll just say one more time that while a considerable amount of ink has been spent historically and recently on Chevron, and it's a worthy topic, I do think and would predict that we'll see an increased focus on the arbitrary and capricious test, and what does State Farm really mean, and how should we apply it? All, to the last questioner's observation, in response to an increased use on guidance or whatever else you want to call subspecies of informal governance that will need some judicial response to that phenomenon. I think, I mean to make a prediction and to state a normative position about
Well, of course, the second step of Chevron, for those of us who teach administrative law, comes very close, overlaps somewhat with the arbitrary and capricious test. And they're analytically somewhat distinct, but it's almost like how many angels can stand on the edge of a pin. All right, well, I think that covers us because it's almost 12 o'clock, and I think the panelists should be thanked for being quite informative and candid.
Thanks so much.
Thank you.
That's great. Pleasure meeting you.
Really nice to meet you. Yeah.
Thanks for moderating.
Good to see you.
Same here.
Hey, good to meet you.
Pleasure meeting you. Yeah, I really enjoyed it.
Yeah, me too.
We have a few populating the administration.
The world would be a better place if we stopped at step one more often.
Oh, hi.